Hello, everyone, and welcome back to our channel. If this is your first time here, my name is Sarah Blakemore. I am the coach of the University of Texas undergraduate moot court team, and today I'm going to be going over moot court argument format. So this argument format that we're going to be talking about today is the argument format you're going to use when you complete your oral arguments. There's somewhat of a different way you're going to do this for a brief, but just keep in mind that this is for oral arguments. So one thing that I want to point out before we dive into this is that I think the greater point of moot court, the greatest challenge of moot court is being able to answer questions. And questions can make or break your argument, whether or not you have a well-rounded, well-presented outline when you start the argument. So this is going to be the outline that you're going to follow with your argument. And this should be probably what you memorize when you are preparing for a moot court competition. So you have an introduction, a roadmap, 3 points maximum, and a conclusion. So let's just dive in with the introduction. There are some things about the introduction that are very important that have to do with courtroom decorum. You get a score on courtroom decorum when you're competing in undergraduate moot court, so this is really important. There are a couple of rules that you just need to follow basally. When your justices enter the room, you're going to stand and remain standing until the justices are seated, in which case you will stand and introduce yourself. You can introduce yourself individually and your partner can introduce themselves individually. One partner can introduce yourselves for both your side and your co-counsel. You'll have your names written on some sort of whiteboard, blackboard behind you or to the side of you, depends on how the room is made up. But you need to identify yourself so the justices know who they're scoring when they write up score sheets. And at this time, you can ask the justices respectfully who will be performing the task of Chief Justice in that round. So another one of these court decorum rules is when you begin your argument, you're going to acknowledge the Chief Justice and the other justice who is there, and you're going to say, "May it please the court." "May it please the court" is just a statement that is said in Supreme Court trials, appellate trials. So it's really the beginning formula for your introduction. And just 2 points here. These are the biggest points that I usually give people when they're practicing for oral argument, but smile. So kind of exude confidence and go slower than you think you want to go. You're usually going to go faster since you're nervous. So this is what an introduction would go like. Chief Justice, Associate Justices, and may it please the court. My name is Sarah Blakemore, and I, along with my co-counsel, Ms. Andrea Somerville, represent the petitioner, Mr. William Denolf, in the case at bar. I will be covering the first issue, while Ms. Somerville will be covering the second issue. This first introduction is for the person who's presenting issue 1. When you present issue 1, you're going to introduce your co-counsel as well. If you're arguing issue 2, you don't have to introduce your co-counsel because they've already introduced you. So you would start off just by saying, "Chief Justice, Associate Justices, and may it please the court. My name is Andrea Somerville, and I represent the petitioner in the second claim of this case." So pretty standard lineup for any way you go in an argument. This leads us into our roadmap portion. So when you're doing oral argument, roadmap is also something that you're scored on. It's part of your organization score. So what you want to do with this roadmap is set up a framework and a structure for your speech. Your roadmap is like your spoken thesis. It's you telling the justices exactly what you're going to speak about, what your vital points of your argument are, and how it comes out. So if you're saying that if you say you're the respondent and you're saying that whatever law passes rational basis, those would be the 2 prongs of rational basis would be your 2 points. You can have a third point of public policy, something that's not vital to your argument because you may not be able to get there. But your roadmap is really your best friend in this argument because it's like your cheat sheet. you will get off track in your argument when you're answering questions. And so this roadmap is the way for you to blend your stuff back, blend what you're talking back into your argument. So a solid roadmap, like I said before, whether or not you're arguing for the petitioner or the respondent, you're going to urge the court to rule in your favor and then mention the lower court decision. I usually do this just because it's a good thing to clarify because of the lower court decision being a part of our case problem that we're given. So you're going to strike down or uphold the lower court decision for two reasons. First, the law does not have an important governmental interest. Second, the regulation is not substantially related to the interest at hand. So this is just an example for an intermediate scrutiny argument, and you might want to include cases in there. You could say, like, this law is not an important governmental interest with respect to the ruling in University of California versus Bakke. And those kinds of things just make your argument pop, and it kind of builds in a recognition for when you're going to mention these cases. It gives you a flow that you can follow. So something that you should keep in mind is that this is a part of your score. I've mentioned this before. If you haven't seen the video on moot court scoring, I would really recommend. But this is a solid part of your organization score, and it's imperative that you have your roadmap memorized so that you can stay organized while you're talking. So you should literally know this forwards and backwards. You can have a justice ask you, the first question they ask you when you start your introduction has to do with, let's say, your second point. You'll say your roadmap, and so they'll technically know that's your second point, and so it will give you a way, a kind of crutch to transition back into your first point, second point, third point. This is, like I said, your one note card. If you were going to bring up a note card to the podium, this would be it, because this is the most basic part of your argument. So let's keep going to the main points of your argument. You can do main points of your argument a whole number of ways. I'm not trying to give you a certain way of doing things. Just the important elements that you need to include in your main points are the relevant detail from the case problem, providing a case site that relates to this relevant detail. So this would be a case of record, drawing a conclusion between the case detail from the record, from the case problem, and then a case detail from the Supreme Court precedent that's cited in the record, and then explain what your overall conclusion means for the case. So the way I do this is, most people in law school would just recognize it as IRAC format. That's a really good thing to look up if you're wondering how this should go. But I start by providing a case that I'm going to talk about. So basically the rule that I'm going to be presenting, it's the initial premise. Then I point out the detail that's in the record, explain how the rule applies to the detail that's in the record, and then reiterate your thesis, and then you can move on to the next point. So just a brief explanation on additional points. Additional points you may not have time for. This additional point that you're building into your argument will help you with flexibility when you come to all these different rounds that you have. You may have a hot panel, meaning they ask a lot of questions, or you may have a dry panel, meaning they don't ask a lot of questions. So depending on how your timing is going, you may want to include a third point in your argument just in case. So these are sometimes called matters of public policy. This is where you can kind of paint a greater picture of your argument, say how this rule would apply to reality, not just the case facts in the record, but the real world, how a ruling in this case would affect the real world. So I put an explanation or an example here from a case last year's case. So public accommodation laws are powerful tools to fight racism in the past and allow universal participation in the economy. These laws encourage tolerance, and tolerance is the grease on the wheels of an efficient market system. So this is this is exactly a point of public policy. That's the most basic explanation I have for it. So again, this should not be something that's vital to your argument because you may not get to an additional point. So let's move on to the conclusion. Like I stated earlier, you're going to have to be very flexible in your arguments when you're presenting in a round. You don't know whether or not you're going to have a hot panel or a dry panel, and it can play out a whole number of ways within that dichotomy. You can have a hot panel in the beginning and then they taper off and they allow you to talk more freely. And you can have a pretty dry panel in the beginning and then they heat up around the end, the second or even third points of your argument. So your conclusion has to be the most flexible portion of your argument. You may not know what kind of conclusion you're going to give until, conservatively 5 minutes into your argument. It just depends on what's going on. You can see what happens to the people who go in front of you. And if you're the first person, you're just going to have to be flexible. So your conclusion will be short or long, depending on how much time you have left on the clock. So I'll start with this long conclusion. If you have a minute left on the clock when you're starting your conclusion, this is, of course, what you would give, this long conclusion. And this is where you can, again, like I said before in the additional point, this is where you get to paint a picture, kind of solidify your argument in key themes of precedent that you've identified during your speech, or you can even re-mention a question that justice has asked, basically something to just reiterate or double down on your argument. You can also include a concession in your long conclusion. This is really good, especially for someone who's arguing respondent, because petitioner has gone ahead of you and they've maybe convinced justices of a certain view. So this is your opportunity to correct that. So just the structure within a long conclusion, self-explanatory, but a topic sentence where you use a conclusion word or indicator just as a transition, state something more abstract about your side and the causes that you're advocating for, restate all your main points, and then at the end, you're going to say, we ask you to rule in favor of petitioner or respondent and uphold or overturn the decision of the lower court. Thank you. And just end your argument right there. If you have to give a short conclusion, this is 30 minutes or less, you're going to use just a basic transition word, restate all your points, and then say this last portion, which is rule in favor of or overturn the lower court decision. You may be in a situation where a justice will ask you a question when you're in the middle of your conclusion or when you're about to conclude. In that case, if time is going to run out before you have the time to answer the question and conclude your argument, before you answer the question, you're going to want to ask the Chief Justice, not an Associate Justice, even if the Associate Justice is the one who asked the question. The Chief Justice is in charge of the time clock, basically. So you're going to ask, Chief Justice, may I have time to briefly answer your or the Associate Justice's question and then conclude? And they'll grant that for you if, and sometimes they'll say briefly. So that's what you want to do. You just want to spend 30 seconds. And if you are in that kind of situation, you don't even have time to give a conclusion. All you're going to say at the end of your argument is, we ask you to rule in favor of the petitioner and overturn the law, or rule in favor of the respondent and uphold the law. Thank you. And that's when you're just going to go and sit down. So I am a rhetoric major at the University of Texas, and so I just wanted to go over a little bit about the rhetoric of your moot court arguments, because it is very important. This is, you're giving a speech that's based on judicial logic or legal logic. So in the rhetoric of the law, one thing that is kind of daunting to new mooters is there's a language associated with the law. There's a type of jargon. Some people call it legalese. So there's a whole number of words that and legal concepts that you'll basically have to know when you're coming into your moot court argument. And you're going to want to be able to use these statements because this is the way that the justices are also going to speak to you. It indicates that you you're an insider in this kind of legal world. So using this specific language, I have a couple of examples here. There are Latin phrases like stare decisis, de novo, ex post facto that are important to know. And if you look at the resources, Moot Court research resources video, there is a link that should have a list of a lot of these definitions and a lot of these concepts and then their definitions, if that is a help to you. Next thing that is really important to keep in mind is your audience. This is wrapped up in the kind of decorum and deference you're going to give justices when speaking and the way that you present yourself. Even though this is a mock-up of a Supreme Court argument, you still have to act like you're arguing in front of the Supreme Court. You're going to address the Chief Justice. You're going to say, may it please the court, these types of things. So keeping your audience in mind, which is part of, and one way of keeping your audience in mind is using the language that this audience uses. And then you also want to keep in mind the deference that you're going to be responding to justices with. So front loading your question answers by saying, yes, Justice, and then continuing your answer, or no, Justice, depending, you want to try to keep it in that, keep it that simple. So the tone of your argument is distinct for both petitioner and respondent. When you're arguing respondent, you're usually the government in our AMCA cases. So you want to be the voice of reason as the respondent, as the government. Basically, you're going to try to beef up how your governmental interest sounds, and then say that this is it's a logical or reasonable application, the law, whatever, of this interest. So what you're going to do, because this is something that's competitive, you're going to want to make your the opposing side sound illogical or unreasonable in the most kind of firm, confident, and deferential way possible. So that's just it's going to be a very matter-of-fact tone that you want to take. And additionally, when you're arguing the petitioner's side, the petitioner is usually in these cases a person whose rights have been violated. And so you want to take on that kind of distinct urgency, because as a lawyer, you are defending the individual rights of a person. And you're going to want to act passionately about that, because this is it's something that you're communicating to the justices with your tone, how you feel about how this case, how they should rule, and the urgency attached to the ruling. Just a continuation of this, this kind of fits in with your tone, but your purpose of your argument is you're going to be asking justices to alter, uphold an act of Congress, in this case problem this year, or an act of the President of the United States. So that's another way that you're going to conceptualize and embody this tone, respect for your audience. And themes, motifs, allusions, you're going to have all of these within your arguments: allusions to case law, allusions to constitutional ideals, founding documents, and whatever you want to use, as long as it's within the scope of the cases on the record. You're going to want to try to have a central theme of your entire argument, something that you can come back to when you get questions. It will provide flow for your argument if you have themes and motifs that you're going to be focusing on in your argument. It also creates a continuity of a thought pattern, which is easier to follow, especially these are oral arguments. Your justices don't get a structure of what you're going to be saying before you say it, before you present your roadmap. So these things are very important. And then last thing, we've talked about this before, but demeanor. The demeanor that you're presenting is, of course, deferential. You're very formal because these are justices of the Supreme Court. But there's a couple different variations you can live in. You can be very professional. You can be professional but conversational with the justices. Try to make a connection with them as you're talking to them. I personally rest in this conversational kind of tone when I'm arguing. So one way that shows up with me is I'll use the justices' names when I'm answering their questions, or I'll allude to a justice's questions just so I'm kind of in conversation with the bench when I'm presenting an argument. You can be aggressive. You can act like you're the champion for your client, whether or not it be the respondent or the petitioner. You can be laid back and calm. There's a whole number of ways that you can do this. And of course, I recommend sticking with something that closely aligns with your personality, because then you can be more natural when you're giving your arguments. It is indeed stressful to give a moot court argument. Accepting questions, especially on when it gets to heat up, when you're in Sweet 16 rounds, elimination rounds, basically, this is something that you can anchor yourself with, the demeanor that you're presenting to the court. One last thing before we wrap up, I wanted to mention logic. Logic is really a kind of underlying concept in the law, but one thing that you need to be very careful of when you're creating your argument structure and your argument is that your argument is satisfiable, which means that when your premises are true, the kind of little things like the rules, like I mentioned earlier, the rules that you're citing. Let's say that you cite a rule from Regents of California versus Bakke that says you can't use quotas for race-based affirmative action plans. So that would be a premise that you would have to accept for your conclusion to be true. And you want your premises to imply your conclusion. So you want them to be deductively the same, deductively similar, so that you can follow each premise all the way to a conclusion. You want to make your argument, of course, as obvious as possible. So I have an example of this from affirmative action cases. I'm really going off on this last 2 years of moot court. But one of these examples, I'm just kind of stating premises here and what they would look like, sentential logic. But if discrimination is on the basis of a suspect classification is something that is not necessary or biological, like a necessary classification would be gender with respect to a lot of things, because men and women, sex it makes them biologically different. So, but arbitrary classifications would be things like race. Race, I'm sure you've heard this before, but race is a social construct. There's no biological thing that makes people a part of a specific race, and even within races, there's more like ethnic and biodiversity within racial groups than there is between. So pretty much an arbitrary classification. So if you have a suspect classification, then strict scrutiny is required. So I have A for arbitrary is a conditional for strict scrutiny. So you're going to use, there's a whole number of times that you can use strict scrutiny, but if you're dealing with an arbitrary classification, you're going to use strict scrutiny. So for a law to pass strict scrutiny, there must be a compelling interest, narrowly tailored, and its means are least restrictive. So right here I have narrow tailoring and a L for least restrictive. Those kind of things are the same. So I have them in one parentheses combined with compelling interest. All of these things together is a condition for passing strict scrutiny. So we have a conditional then passes strict scrutiny. Now that I'm thinking about this would actually be a biconditional, because the only way for you to pass strict scrutiny is through these rules. So it would be narrowly tailored and least restrictive means and compelling interest if and only if P, the passing. So that would mean if it passes, it has all of these things. And if it has all of these things, it passes. It's a conditional that works both ways. And means are narrowly tailored only when it affects the general interest or the legitimate interest that's being pursued by the government. This is another biconditional statement we have here. So narrow if and only if there is a compelling interest. You can only have, you can only evaluate something for its narrow tailoring once you know that there is a compelling interest. So that's what I have here in sentential logic. The reason I mention this logic stuff is it's a very, very important exercise to map out the logic of your arguments and then see if they're satisfiable, if they're valid, if they are deductively implied, because this is, I mean, that's the most basic way to get caught in an argument is by presenting an illogical argument or one that doesn't work in all cases. So you want to keep that in mind. But as we wrap up here, there's a lot of things to consider when you're doing a moot court argument. Like I mentioned before we even started this video, that questions are going to be really what make or break your argument, and you're going to have to be very full within your argument. So just a tip I have for that is focusing on your rhetorical themes. These themes and motifs, they're the through line for your entire argument. So remember to be flexible. You don't know what kind of speech you're going to give, and every single argument you're going to give is going to be different and distinct fingerprint. So have confidence with yourself and confidence within your work that will come from memorization and practice. And I wish you all good luck. Hook 'em.